Hello everyone, my name is Mustafa. I'm an associate professor at Ufa University of Science and Technology and also legal counsel. Welcome to my channel, Mustafa Contract Law Hub, where I'm planning to tell you about everything you need to know regarding contract law. Whether you are a student eager to learn or a professional sharpening your skills or just someone interested in understanding contracts better, you've come to the right place. So, let's dive in and explore the fascinating world of contract law together. Today, I'm going to talk about this important concept on the contract law. I told you about the capacity that was one of the requirements to make new contract, and this capacity, as I told you, is legal ability for every legal person or natural person to make new contract. So I told you sometimes this capacity may be based on some circumstances are not convinced, and the special people like minors or drunk people or some people suffering mental diseases, mental disorders, they don't have capacity and they are considered to be incapacitated and they can't make new valid contracts. So today I want to speak about the corporations, because it's not only about the natural person, but also the legal person, legal entities, corporations in general. They have such a capacity, because this capacity is one of the aspects of legal personality that they have. So today I'm going to tell you about this concept under the civil law and common law. As I told you, the capacity is one of the aspects of legal personality, and every legal entity, every company, organization, or in general corporations, they have such a capacity to make new contracts. But it's important to know, in both legal systems, civil law and common law, we see some similarities regarding capacity that sometimes in some special circumstances the corporations don't have capacity to make new contract, new valid one. Today I try to tell you about all these circumstances. As I outlined here, you can see 6 circumstances, and first of all, as you see here, is lack of legal personality, and also the next is the entering into contracts that outside their object. It's not so strict today, but I'm telling you about the aspects around this one. And also lack of proper authority of the representative, and insolvency, dissolution, and at the end some prohibitions by some special statutes. So here, first of all, I want to speak about the lack of legal personality. It's general rule that every corporation has legal personality, and when they have legal personality, one of the aspects of this legal personality is making or creating contracts, valid contracts. So at the time of registration or incorporation under the common law or civil law, we have valid new corporations. But before them, at the phase of pre-registration or pre-incorporation, we don't have such a valid corporation to make new contracts. When we don't have such a valid one, so we don't have such capacity to make new valid contracts. It's the important one to know about them. So from the registration, everything is in validity. And you know, when we see such contracts, that we call them as pre-incorporation or pre-registration contracts, what should we do about them? We have contract that's signed by the people who are acting on behalf of the corporations, but these contracts are not at the time of registration, or still we don't have corporation, and when we don't have corporation, we don't have legal personality. So about these contracts, this type of contracts, only we must do in this way, that after the registration or after the incorporation, we need to ratify them by the individuals who are acting based on the authorizations that they have and the powers that they have on behalf of the corporations. And also exceeding the company's object. In fact, sometimes you see some works or activities that are beyond the objects of the corporation or outside this object. In both legal systems, civil law and also common law, we have such a concept that in fact, I must divide them in history and see them in history and also in modern law. Because in modern law, today, we see more flexibility under the civil law and common law. But we see strict rules regarding this object in the history. In the past, if we needed to know about the capacity of the corporations, so every corporation must do based on its object, and this is a strict rule about them. But today we see more flexibility. In the past, we saw them as ultra vires. For example, if the corporations do something based that they are not based on their object or beyond their object, in accordance with the strict rules, so it's not valid. But right now we see the situation case by case must be analyzed, because if we have some objects and on the other hand we need to, for example, make some contracts for the works and activities of this corporation, so maybe we need more flexibility. Even this object or this new activity that is leading to new contract is beyond and outside the capacity of or this object of the organization or company or in general corporations. So right now we see more flexibility about the object. So lack of authority of the representative who they are acting on behalf of the companies is another important thing, because on the one hand, if we have corporation and this corporation must have capacity, and this capacity permits them to make new contracts, so on the other hand we need to have some authorized people who are acting on behalf of the company that are capacitated and they have power to do it based on the constitution or based on the special statutory. So we need both of them, capacity of the corporation and also the powers and authorization of the individuals that they are acting on behalf of the corporation. And this is the similar concept in civil law and also common law. The next one, insolvency. About insolvency or bankruptcy, we have similar concepts or similar rules under the common law and civil law. Most of them trying to say, in general, when we are at the time of bankruptcy or insolvency, so the corporations are limited by law. That only do something is needed for the process of bankruptcy or the process of the insolvency. In fact, they can't do any special new businesses unless there is permits of the authorized person or the permits of the court. But otherwise, they can't do it, and only the contracts are valid at this time that they are helping to the process of insolvency or administration ones and so on that they are needed at this time, not business ones. And this is similar concept as you see here. For example, selling assets or settling the disputes at this time is so important, and if we need some new contracts related to settling the debts, so it's accepted under the common law and civil law to make new contracts for this purpose. And dissolution is another one, or liquidation. At this time, only we see that the corporations try to solve the current situation, or they try to settle the existing disputes, and the settling the existing situation, not entering into new one, because entering into new one is another story and is not permitted by the law at this time. Just we need to solve the situation and every administrative works that we needed to do at this time. So it's again a similar thing between the common law and civil law. And the last one, specific statutory here, that is so important because sometimes we see some specific prohibitions or restrictions for corporations based on the specific statutory. So we must case by case analyze what type of corporation we have and what type of actions we need to do, and is it prohibited by some special statutory or no. It's case by case and must be analyzed situation. Here you can see this figure. If we have a corporation, in general, all of them have this power, legal capacity or legal ability to do their works, because it's one of the aspects of legal personality to make new contracts, and for making new contracts, they need such capacity. But sometimes, as I told you, under the common law and civil law, we have 6 circumstances that all these circumstances may lead to incapacitated situation. So here you can see lack of legal personality, or here entering into contracts outside the object, and lack of proper authority of representative, and insolvency or bankruptcy and dissolution or liquidation, and specific statutory prohibitions or restrictions. And in conclusion, as I told you, both of these common law and civil law trying to speak about this general rule, and also these exceptions, these circumstances that the corporations, they don't have legal capacity to make new contracts or to conclude new contracts. Thank you so much again, and again I must emphasize I have beautiful information for you, and I wish you the best. Stay with me because I want to tell you more and more about the contracts. Wish you the best. Bye.